been a long time coming, but I know change will come. Oh, yes, it will. It's been too hard living, but I'm afraid to die, 'cause I don't know what's up there beyond the skies. It's been a long time coming, but I know a change gonna come. Oh, yes, it will. I go to the movie and I go downtown, and somebody keep telling me don't hang around. It's been a long time coming, but I know a change gonna come. Oh, yes, it will. And then I go to my brother, and I say, brother, help me please. But he winds up knocking me back down on my knees. Whoa, there've been times when I thought I couldn't last for long, but now I think I'm able to carry on. It's been a long time coming, but I know, come on, amen, corner, but I know a change, a change is gonna come. Yes, it will.
It is an honor to be here, just to be in the presence of all of you that scheduled the panel before lunch. I was humbled and inspired to hear those stories of their lives and their sacrifices and the struggles that went on to bring us to this day. So I'm going to tell you a few stories as a retired historian, and try and I also want to thank my friend James Williams for giving us this opportunity. We just marked the passing of Reverend James Lawson a few weeks ago, one of the foundational figures in the movement, the architects of nonviolence. And there's so many things that we could be and are thinking about as we watch the news. To take a moment just to consider this piece of legislation is an important thing. And thank you, James, for giving us the opportunity to do that. My father was a South Carolinian who served in the Army during World War II as a chaplain in a segregated unit that served in France. When the war was over, he was honorably discharged at Fort Dix in New Jersey and went to visit family who lived in that state. When he got to their town, he stopped at a drugstore to buy a Coke and to get some directions. He was wearing his uniform when the man behind the counter told him that they did not serve Negroes. A little less than 20 years after that, my father and I were traveling south from our home, which was then Atlantic City. It was just a few weeks after the Civil Rights Act had been passed. He wanted to test it, and he took me along. We stopped at a Howard Johnson's restaurant in Virginia. The hostess seated the white people who were in line ahead of us, and then came back to seat the white people who were behind us. But they told her that we were there first. That bothered her, but without being rude or polite, she proceeded to seat us at a booth. I was about 15. I was terrified and very proud to have that meal with my dad in that place that day. It had taken a great social movement, a moral crusade, and an act of the Congress of the United States to make that meal possible. 20 years after that, I was teaching history and African American studies at the University of North Carolina, something that my grandparents could not have even imagined. Much of my life today would be improbable and probably illegal were it not for the Civil Rights Act of 1964. I could not have worked where I worked, probably could not live where I live, eat lunch where I choose, stay in hotels when I travel, be a member of the downtown YMCA. In fact, the chances are that even my presence in this public library would be awkward or illegal were it not for the passage of that legislation. I tell those stories in order to accurately measure how far you've traveled, you need to recall where you started. Before July 2nd, 1964, by law and custom, power and authority was white and male. Of course, there were significant individual and institutional exceptions, but that was the norm and the expectation. In 1966, Pauli Murray joined Betty Friedan in forming the National Organization of Women, in part to press for more vigorous enforcement of Title VII that banned discrimination in employment, including discrimination based on sex, a right that had not been established in law prior to the passage of the Civil Rights Act. It was also in that year, 1966, that UNC hired its first Black faculty member, Hortense McClendon, who I believe is now 104 years old, living in Silver Spring, Maryland. Even now, and even with the present Supreme Court, the Civil Rights Act still has the ability to provide protections and create opportunities. A statement issued by the American Bar Association a few years ago said, and I quote, "In a monumental decision from a trio of cases issued on June 15, 2020, the United States Supreme Court ruled that Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of sexual orientation and/or transgender status." Less than 2 months ago, the Legal Defense Fund issued this press release concerning the case of a Black woman police officer in St. Louis. I quote, "Today, the Legal Defense Fund lauds the U.S. Supreme Court decision in Muldrow versus St. Louis that preserves the goal and intent of Title VII of the Civil Rights Act of 1964, which protects employees from discrimination in the workplace. We need a proper measure to judge the legacy and impact of this historic piece of legislation. It was not designed to end racism or all the enduring impacts of racism, or to prevent the resurgence of racism. It was designed to put the weight of federal law against those who deny access to public accommodations, education, or employment on the basis of race, color, religion, sex, or national origin. This law was one important legal expression of a wider, broader, ongoing movement for social, racial, and economic justice that we have heard so much about already today. In addition to the well-known civil rights leaders and activists, its passage required the skillful, persistent, and effective advocacy of less well-known insiders who knew the machinery of how Congress worked. People like Clarence Mitchell Jr., chief congressional lobbyist for the NAACP, and Louis Martin, a Black journalist and influential White House advisor during the Kennedy and Johnson administrations, and Joseph Raw, counsel for the Leadership Conference on Civil Rights. The bill also had the active support of the National Council of Churches, the American Jewish Congress, and the Friends Committee for National Legislation. In addition, it had the strong backing of Walter Reuther and the United Auto Workers, and also the AFL-CIO. But even after it was passed, the new law might not have become a real ongoing instrument for change had it not been for the work of some brilliant and courageous attorneys who used it to achieve justice. People like Julius Chambers, James Ferguson, Adam Stein, Mel Watt, Jack Boger, Ted Shaw, a tradition that is carried on today by other notable participants in this symposium and on this panel. And people in the audience, it is an honor to be here with all of you. The 11 sections of or titles of the Civil Rights Act addressed a range of issues and established the Equal Employment Opportunity Commission and the Community Relations Service. Deals had to be made to move the bill through Congress, but the reach of the legislation was still remarkably broad, ambitious, and necessary. In some ways, this 60th anniversary is a moment to ask, how shall we measure progress? And how, 6 decades and 3 generations after the passage of the Act, can we refine, recalibrate, and renew our efforts to complete, sustain, and extend the work that was started in 1964? And how can we do that during a time when programs for diversity, equity, and inclusion are under attack, and when even the term DEI has become a pejorative? When Julius Chambers won the landmark Swan versus Charlotte Mecklenburg's Board of Education case in 1971, 71% of the students in that school system were white and 29% Black. A report from the Axios News Service issued in May says, and I quote, "Charlotte was a beacon for integration in public schools from the 1970s to the 1990s. Today, like public school districts across the nation, Charlotte-Mecklenburg schools have once again become segregated. The discussions around integration in the 20th century," it goes on to say, "focus on Black and white students. Today, it's a larger conversation about Black students, who make up 34% of the student body, Hispanic students, 31%, and white students, 23.7%. A study done 10 years ago by the Civil Rights Project of the University of California found that students in North Carolina schools are increasingly isolated by poverty. So, how do we, how should we measure progress? What are the goals we are now trying to achieve, and how can we best achieve them? I cite these studies and figures as observations, not accusations. In no way does it dampen the magnitude and the significance of what was accomplished 60 years ago. To acknowledge that present efforts have to be overhauled to deal with present realities. Even as history is celebrated, it also has to be critically engaged and learned from in order for us to know how to measure progress and how to take the next steps forward. Title VII dealt with employment. I can remember when the first Black person was hired to be a cashier in a Woolworths in Atlantic City. It was a big deal. We've come a long way since then. But to get a sense of the economic work yet to be done, just attend any rally by the Poor People's Campaign led by Reverend Barber and listen. The line dividing the poor from the wealthy is as stark, as demeaning, as harsh, and as determinative as was the line between the races in 1964. And today, as then, the categories of race and poverty often overlap. During the first quarter of this year in North Carolina, the rate of unemployment was 2.6% for whites, 3.6% for Hispanics, and 6.1% for Blacks. My guess is that young Black males made up a disproportionate part of that 6.1% at a time when the boom in construction and construction jobs continues in Chapel Hill, Durham, and Raleigh. Just one idea. Would it not be possible for some level of government to provide incentives and establish goals and guidelines to encourage the building trades to specifically recruit, train, and employ workers from poor Black communities in order to establish diverse, inclusive work crews? As I said, I'm a retired historian. I don't pretend to know the answers. But I do know that the problems of today are no more daunting than the problems that were faced 60 years ago when die-hard segregationists controlled the major committees in Congress. And I do remember that meal I had with my dad at a Howard Johnson's in Virginia in 1964. So I know that things can change.
I have a more modest task, at least that I've set for myself, thank goodness, because I couldn't get anything like what I've seen with the rest of you. It's really to talk about how education was affected by the Civil Rights Act of '64. And somewhere it may go up a slide presentation that I prepared for an event that Lloyd Kramer knows about in May, and it's modified just a little. Because it occurred to me, even when I started to think about the Civil Rights Act of '64 and education, you can't start in 1964. You need to start in 1954 with Brown versus Board of Education. We all remember the basic conclusion of that is that the question was ranked: does segregation of children in public schools solely on the basis of their race, even though physical facilities be equal, deprive the students of equal educational opportunity? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Now, all of that was wonderful. But of course, Brown versus Board was a play in two acts. That was the 1954 Lofty Act. Back the case comes on re-argument to the courts in 1955 on what do we do next. What the court held there, as you may remember, was because there's so many different local situations and potentially intractable problems, we're going to send these cases back to local courts all over the country and let those sort out what has to be done and when. The court made some gesture that there needs to be a prompt and reasonable start, but of course the famous language was that move with all deliberate speed. Well, why this very strong start? Why this incredibly weak and amorphous second act? The answer, it seems to me, lies in the circumstances that faced the court at that time. The court has no more personal power than a bunch of bailiffs who can actually make you sit down if you get rusty, but not much else. They can keep the front steps of the courthouse okay, and that's the limit of their power. What they have to look to is the other branches of government. They have to look to the executive branch. And there was a President, Dwight Eisenhower, who in candor, while he said nothing against Brown versus Board of Education publicly, privately was very unhappy with it. But even worse, as Reg suggested, we had a Congress at that time under which the Senate was controlled by a system of seniority. And every committee in Congress was led by the senior-most senator, and guess what? Southerners had learned that all they had to do was send people back, James Eastman, Herman Talmadge, whoever, to Senate over and over again, and every one of the major committees was in the hands of Southern senators. When you look to the states, you saw governors and Congress people and other state legislatures who were quick after Brown to join in a Southern manifesto, which said Brown was wrong, the Constitution doesn't require this, we will affirmatively resist it in every lawful way. Indeed, in Virginia, they called it massive resistance. And the governor said, if a single black child goes to a single white school, I will close those schools. And he did. Now, all of that power then was going to be laid against this wonderful holding. And you had federal judges in the South who had grown up under the regime of white supremacy, and yet they were going to be the ones to enforce this. Now, what did Brown do? It seemed to me that what Brown did was something revolutionary, because for the very first time in the United States courts, African Americans were treated as if they were full first-class citizens entitled to everything that anyone else was entitled to, not at sufferance. We may give you this if you're good, we might give you, but no special privileges to you, etc. It simply said, if you were a child, you will go to school like other children. But it didn't, of course, answer the question of what did that mean. One black child in an all-white school, one white child in an all-black school, and we've done the deed. Or full desegregation. Does it go only to students? Does it extend to faculty and staff? Does it extend to other areas of life, like transportation to and from schools? None of that was answered. Well, the South basically took the position initially in court and in executive actions that it would fight to the death. Indeed, in Georgia, it was made a felony if you, in fact, moved to desegregate a school. I know they didn't follow that up, but they made it clear this is a violation of law. So what, in fact, moved things forward? My slideshow would show, they're struggling with it. That's all right. That's all right. I can actually convene it out of the air. This wonderful group of young people who took to the streets, Dr. King and the Southern Christian Leadership Conference, the SNCC and John Lewis and Ella Baker and all of those folks that we heard about, and the people who had been locally working to desegregate Colonial Drugstore and the rest, they moved into action. And they began to apply pressure all over the South. In addition to that, the NAACP filed 170 lawsuits. Most of them didn't go anywhere right away, but they did keep things moving forward. Then, as was alluded to in one of the excellent previous presentations, Judge Wynn really was on this. As John Kennedy becomes president, as Dr. King moves into Birmingham and their fire hoses taking 13-year-old daughters and sons and throwing them around under the pressure of 2,000-pound hoses, as Birmingham Sunday takes place, there begins to develop a sense in John Kennedy and the administration, we've got to take some action on civil rights. And then, of course, after his horrible assassination in Texas, eyes turned to the Texas president, who'd never been a particularly strong civil rights advocate, and he made the decision of his life, which was, I'm going to push through a strong civil rights bill, and it's going to be the legacy of Kennedy and all of us. He knew what that would cost. He said privately, according to his biographer, this may be the end of the Democratic Party in the South. It must happen. And so it did happen. And the Act had two provisions that dealt with education, which was my topic, remember. The first seems innocuous. It simply says that we're going to allow the Attorney General to intervene in education suits. Now, law students are often surprised and say, what do you mean? The Attorney General can go wherever she or he wants. But that's not the case. They've got to have statutory authority to intervene, and this said they can. They can intervene in K-12 lawsuits if there's not enough lawyers to handle the matters. They can intervene in college suits. Now, what did that mean? It meant, God bless Ferguson, Stein, Chambers, Rutz, all those folk who were there in the field. But I can count your names really, in 5 or 10 seconds. There weren't hundreds of lawyers. And indeed, North Carolina was especially blessed because of the wonderful lawyers who were in this state. In other states, there were many people who were willing to bring those lawsuits. All of a sudden, in Georgia or Alabama, the plaintiff seeking entry into the school can say, I'm represented by the United States of America. By Ramsey Clark had become the Attorney General. Ramsey Clark, one of the most radical people that's ever been Attorney General. John Doerr, who had stood in, gone to Mississippi and seen the horrible face of white reaction, was the head of Civil Rights Division. So all of a sudden we're going to have power to bring suits everywhere. But more important than that threat, in a sense, was what happened the next year when the Congress passed the Elementary and Secondary Education Act of 1965. So all of a sudden what it did is take hundreds of thousands of dollars and put them on the table and say, all your school districts, come get this money. But wait a minute, there's Title VI of the Civil Rights Act of 1964. And if you're discriminating, you don't get any of this money, okay? You stay over there. The rest of you, please come. We're just handing it out. And sure enough, the combination of the threat of litigation and the incentive of getting positive dollars began slowly to melt the glacier that one thought could never change. And at that moment, the Supreme Court started to realize again, as it had hoped to in 1954, we have allies. We have allies in the Congress. We have allies in the executive branch. We have allies finally in the federal lower courts. And they began to move in a way that they had not been forced to but once since the Brown decision, and began to say, we have got to pass additional or decide additional cases to clarify how education will be implemented. Quickly to one of those, and then I'll promise to stop very, very soon. In 1968, William Brennan, and perhaps the finest decision that he wrote, said in the Green case, we had Brown in 54, we now have Green in 68, said that the time for even freedom of choice, where parents can decide whether their children will go to a black school or a white school, is over. We're going to look at results. We're going to look at results with respect to student populations, with faculty, with respect to staff, and if we see schools that can be identified as black schools or white schools, those schools are in violation. And federal judges, it's your obligation to push those with express orders so that all of that is ended. And the next year in Alexander versus Holmes, one of the local school districts said, we need another year. And the court came out in 1969 and said, there are no more years. We're out of time. We've had 1954 to 1965, that's almost 15 years, right? If you can do your math, and the time has come for full implementation. And here's the one place I guess I wish I did have my charts up, because you see these dramatic results, which I'll have to go to my own little thing to find. I'm glad I brought this, because the numbers are absolutely remarkable. Charlie Clodfelter over at Duke did a table in which he looked at the percentage of black students in 90 to 100% non-white schools. In the South, in 1960, it was 100%. In 1968, it was still 77%. 4 years later, it was 24%. 2 years after that, it was 22%. So you go from 100% segregation to 77% in 13 to 14 years after Brown, to, given the description of what began to happen, 24%. And it stayed low all the way through the 1970s and into the 1980s. By the way, the North at that time, when the South had only 22% of blacks in 100% of black schools, it had 51%. So the South became, through these methods, the most integrated part of the country. Now, there was some terrible cost to integration, I need not tell you, because the decisions were made to strip, it was like about nurses, strip the African-American administrators and teachers out of the integrating schools. We lost a wealth of great talent, and the courts were slow to address that. But nonetheless, there was a remarkable amount of desegregation. And then times changed. The courts changed. The Earl Warren Court became the Warren Burger Court and the William Rehnquist Court, and they began to look for ways to shut down the change that had happened. They did so with the support of lots of folk all across the country, white folk particularly. Ironically, a lot of people in the North who had rooted for Southern desegregation, when desegregation moved north, said, no, we didn't mean that. We meant it for the South. And indeed, the Supreme Court, in one of the most crucial decisions in 1974, the Detroit case, Milliken versus Bradley, said, we're not going to allow you to order desegregation across district lines. Well, the irony was that in the South, those school districts were countywide, and so they really caught most of the population. I did a litigation in Hartford, Connecticut. There were 21 school districts in Hartford, in the metropolitan region. 18 of them African-American and Latino, 3 of them white. And you couldn't move people across those lines. Well, so we've had a dramatic move toward resegregation. Red just mentioned that Charlotte had one of the most desegregated school systems for 25 years. When Ronald Reagan came to Charlotte, he thought he had taken the measure of it and said, I'm sure glad you don't have, the kind of racial pressure that you had for integrated schools, and was booed by local folks because they were proud of what had happened. By 2000, Charlotte had moved back to neighborhood schooling and lots of resegregation. And that's all stuff. That's where we kind of are now. We don't have pressure from, obviously, the federal courts at this point. We certainly don't have pressure from Congress. We maybe need some movement in the streets again to support what's been going on. But it is possible it will happen again. Judge Wynn assured me ahead of time, and this is coming from a federal judge, so you know it's true. The pendulum always swings back.
This moment in time at lunch with your father reminds me of how critical these early development moments in our lives can be towards launching us on a trajectory that can have a huge impact on people's lives, which you certainly have. I wanted to talk today about the politicization of our courts and the impacts of that. I have no real credentials to talk about such things. other than the fact that, like many civil rights lawyers in North Carolina, including Justice Earls, who's in the audience, we have suffered greatly, personally and professionally, due to the politicization of the courts. And yet we've also, I think, gotten a very clear calling about how to step forward and resist and speak truth to power under these circumstances. So I'm going to do what I hope will be sort of a call to invite you to investigate some of the things that I've been talking about and that I'm going to talk about, and to think about them. It really helps me, your last words, Jack, about the pendulum swinging, I mean, it's right there. And the only thing I wrote that I would start with, if there's any comfort to be derived from this notion that the pendulum swings, right? It unfortunately rapidly evaporates when one considers the full implications of yesterday's ruling from the Supreme Court, which forsakes core principles of democracy for a return to monarchical rule, right, in form, or more aptly described, should the worst come to pass this November, despotic dictatorship. I think dates are important. Anniversaries are important. Today's actually the anniversary that would have been our Independence Day, right? Except that it was delayed because the instrument that ushered in our new being as a country had to undergo some edits to take out the criticism of English and some English people and slavery. So, sanitizing this document and removing race, the reality of race from it, is what happened today, a long time ago. And then today also, of course, marking the 60th anniversary, the events of yesterday become even more stark for me, given their timing. And Chief Justice Roberts' quip that the dissent, and if you haven't read this opinion, I think every American should, it should be taught in our schools. Chief Justice Roberts' quip that dissent strikes a tone of chilling doom disproportionate to what the court did, evokes, and I hesitate to say this, I wrote it this morning, but without any disrespect and a huge amount of respect and honor, that, when I read it, the image that flashed in my head, and I'm a white, WASP, Protestant, privileged girl from Mississippi, okay? But it evoked the image of Nazi guards telling Auschwitz inmates on the way to the showers, you're going to get clean. You're going to take a shower. To me, a lover of justice, that is not hyperbole, right? It's a death. It's a mass death, a mass murder. And I find hope, because I'm ever the optimist, clinging to my Marxist roots, in the notion that the death of democracy in this country might give rise, as we saw a rise in the 50s, it was long before the 50s, right? Black people, Pauli Murray, struggling way before 1950 to make justice a reality in this country. But it might give rise, just as it did then, to a revolution for justice. We shall see. I have 18 and 20-year-old sons. They watched the debate during a family vacation last week on a cruise to Alaska, of all places.
Braver than me.
And they came back, well, that's why I have my mask here, but they came back along with their cousins, all of them teenagers and young adults, with so much rage in their eyes, so much rage and disrespect and disaffectation. And I just hope, and I go to poor people's rallies and I go to, I get in the streets, I hope that that disaffectation is a necessary step towards what will ultimately be something that must be greater than anything we've seen before in terms of social movements in this country. So, I don't know about you, but I like to make sense of it all. I mean, that's why I went to law school, actually, to make sense of it all and to find some sort of understanding of the source of this movement, the reactionary right-wing movement on our courts, and how it's spread, and what its impacts are in our day-to-day lives. And I'm just going to, by way of, referencing a lot of the information I'm talking about today, this book, which was written in 2021, Linda Greenhouse, Justice on the Brink, the subtitle, The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and 12 Months That Transformed the Supreme Court, I recommend you read this before you read yesterday's opinion. It will really, really help you get through the opinion and to understand the long game that was played, that is still being played, but that was really crowned yesterday by Roberts' opinion that he authored and was joined by his cohorts. It is a long game, and Linda Greenhouse's books really helps understand each step along that path, and so I do recommend that. The source and the roots of the issue that Linda Greenhouse sort of evoked for me, and she doesn't say this, but it really is. It came out of reading that and knowing the opinions that she was talking about, because Jack Boger taught them to me in school, in law school, some of them, of course they point to race, right? The parents-involved decision in the 2006-2007 session of the court, in which Roberts said that resisting resegregation, the resegregation that Jack just talked about, which is a stark reality that schools are more racially segregated today than they were in 1970, is telling, right? He said that avoiding resegregation is not sufficiently compelling to justify a racially conscious student assignment plan. There was, from that time to the 2006-2007 session to 2012, when Shelby County v. Holder was decided, which decimated the Section 5 of the Voting Rights Act, which was the provision that, the provision that requires a preclearance by a federal court if a jurisdiction that had engaged in segregation tried to make a change to voting rules or procedures. That the formula for that preclearance and the formula for deciding who had to go through preclearance was Section 4, which was technically what was at issue in Shelby, but we know the effect of that was to really kill a provision that was the only one, right? Unlike Section 2, Section 5 was the only provision of the Voting Rights Act that had a proactive method to prevent excluding Black and brown people from their franchise, from their ability to vote and select a candidate of their choice. And so these decisions, the Roberts comments in the Roberts' two-stage strategy with the Shelby County v. Holder decision is you can see the common thread in parents involved in Shelby County v. Holder, in the subsequent decisions about schools and funding of schools, and religion emerges over and over and over again. what Ruth Bader Ginsburg and Linda Greenhouse call the last taboo, right? I think it's important to think about this problem. I've seen it over and over again in our state courts, right? Our state appellate courts, in the movement to draw dollars, public dollars, away from our public schools and divert them to private schools that engage in discrimination on all kinds of levels, right? But this idea that religion, that the church, right, is its own entity whose authority and rights are protected over the rights of the individual, over the rights that are enshrined in both our Declaration of Rights and in the Civil Rights Act of 1964, which made those rights real for people. So just a couple of numbers, because numbers are telling, as Jack just showed us, right, with a slip from advances in bringing children of all races together in the most important activity that they have, which is to learn together, to compete together in public schools, that the decisions that have come down from the Roberts Court since the end of the Rehnquist Court in 2005, individuals claiming a religious right prevailed about half the time under the Rehnquist Court, with little difference between the two political parties, the Republican and Democrats, in terms of the justices, how they were appointed, right? So justices appointed by Republican presidents ruled for religious claims 56% of the time, and those appointed by Democratic presidents were 47% under the Rehnquist Court. Under the Roberts Court, religious claims prevail 90% of the time. And here's how they break down in terms of the justices and where they rule. Kavanaugh, 100%. Gorsuch, 100%. Thomas, 94%. Roberts, 93%. Alito, also 93%. Kagan, 73%. Ginsburg, God rest her, 21%. Roberts declares in 2021 in an employment case with the Lutheran Church and School versus the EEOC that, and these words I tell you, tell it all, the church must be free to choose those who will guide it on its way. This is an employment case. The church must be free to choose those who will guide it on its way. Who is this church? How does the court justify giving priority to the rights of the legal fiction of the church, says Greenhouse, over the statutory rights of individuals? So then we have the next range of cases, right? You heard of the Hobby Lobby decision in 2014, the Little Sisters of the Poor in 2016. What are these cases about? These cases are about abortion, religion, abortion. Abortion, what Ruth Bader Ginsburg termed the only way, right, and I paraphrase, but key to a woman's liberation, a woman's freedom, right, the right to abortion. The whole women's health decision. This string of cases, if you look at them all together, you can see the path. Roberts says, how could a court appraise the supposed benefit from an abortion restriction? How could this court appraise the supposed benefit from an abortion restriction? He asks. I mean, these are keys to, I think, understanding where we're headed, and also how to go about attacking it, right? What is our strategy to deal with these with this trajectory? So I don't have time. I want to leave enough for Reggie and for questions. But the continuation of these cases through those that deal with the religious claims of prisoners, the religious claims of in Fulton v. City of Philadelphia, with the foster family case, and the decisions, the language from the court. Now we have Coney Barrett, and Barrett, in her first her first opinions, her first decision, her first participation in decisions, you can see this sort of approach, a sort of a nuance, right? Almost a nuanced approach, especially compared to her colleagues, about how far we need to go with holding the religious right supreme. Alito and Kavanaugh, provide that sort of far-right voice on the court to make religious rights and calling it free exercise, elevated above all else, right? The recent decision in the mifepristone case, again, it sounds like I'm mixing them all up together, but when you look at them taken in sequence and the language in those opinions, you see the connection between the elevation of the religion and the religious right, the church as an entity, abortion, right? The right and access to an abortion, and then we go into Trump's last few months and his death spree, right? Killing more people on death row than had been put to death in the 15 years prior, right, to his administration. At a time when this country was beginning to come to some sort of terms about the death penalty, states, right, through the democratic process, coming to terms with what the death penalty means about humanity, had pulled away from it, had directed their legislators to pull away from it. And here comes Trump in his last days, making sure that as many people are executed as possible. And the religious claim for prisoners, how they were dealt with, right? The only prisoner, death row inmate who was approaching his death, who did not have his death stayed because of his religious claim, was what? Muslim. Then in 2020, we have the Voting Rights Act case from Arizona, the Brnovich v. Democrat National Committee. And I was a civil rights lawyer up until last August. I took a year off and joined in 2020, in August of last year, 2023, I joined American Oversight, which is a democracy watchdog organization that that does public records investigations. We're equal numbers, lawyers, researchers, and paralegals, and we submit public records requests. We've submitted a lot of them. We have some that are never going to get answered about Justice Earls, the attack on Justice Earls by the other justices and the legislators that put them in place. And that public accountability and information, pursuit of information to share with the American public, to give you the information that you need to make decisions, I think is where I need to be right now. It's certainly wonderful work to do and people to work with. And it's interesting because Arizona is my state, and I'm litigating a couple of cases right now around the fake electors conspiracy and the efforts to keep people from being able to vote keep black and brown people from being able to vote in 2024. And it's interesting that this case comes back up, the voting rights case from Arizona in 2020, which dealt with this requirement that, again, the requirements that keep people from being able to vote, particularly African American, Native American, and Latino voters. And we see that decision, we see Robert's opinion there, we see the Second Amendment cases, the gun rights cases, again, this question, and then we see what happened yesterday, right? And so I think it came to me that it might be a good thing to do to challenge this concept of the church and bring instead a discussion about that goes back to, I think, core values of humanity and I think Christianity, but also Islam and other faiths that focus on the divinity of the human experience and the reasons why we should all see ourselves in each other and treat each other equally and with respect. And I think it's really interesting to look at how that formulation of religion is being used once again to justify segregation, deprivation of access to the vote, to public schools, to employment, and reframe the argument. So here you go, Reggie.
I absolutely should introduce myself. I have no sense that anybody even know who I am either. But I'm Reggie Shuford, and I'm the Executive Director of the North Carolina Justice Center. I've been back in North Carolina since February of last year, but who's counting? So it's good to be with you all today, and thanks to James and the organizers for the opportunity to participate in today's important conversation. So any opportunity to return to Chapel Hill is a good one for me. I'm honored to be on this distinguished panel with folks I've known and admired for a very long time. Today is a first for me, the first time I've sat on a panel with two former professors from both my undergraduate and law school days. Two of my favorite professors, and I can't get a grade, but I mean it sincerely. It's a full circle moment, and I'm really honored to be here. Very happy to leave the legal scholarship to Jack and the nuances of American history to Dr. Hildebrand. And Elizabeth, my friend, especially happy to lead the discussion of the Supreme Court to you. My only comment, and I just added this, I hope it doesn't get me in trouble, but my only comment is scary. And Fulton versus City of Philadelphia was one of my cases before I moved back to North Carolina. So in my brief time, James asked me to talk about America's criminal justice system in 10 minutes. In particular, mass incarceration. Given the focus of today, implicit in that assignment is assessing the impact of America's criminal justice system on Black Americans and whether it advanced or undermined the goals of the Civil Rights Act of 1964. I think we all know the answer to that question, but given the rampant and persistent racial disparities throughout the criminal legal system, any discussion of this would be incomplete without it. I hope I understood the assignment. So in 1995, I moved from North Carolina to New York City to work at the National ACLU. And thank you, Jack, for your recommendation that probably got me hired. To work primarily on racial justice issues. Most of my work there focused on the intersection of race, policing, and the criminal justice system. I helped to design the litigation model challenging racial profiling, mostly driving while Black, and class action lawsuits throughout the country. A principal driver of racial profiling was the war on drugs. Black Americans are stopped and searched disproportionately on America's highways, notwithstanding a typically lower hit rate as compared to their white counterparts. Racial profiling proved not only illegal, but also an inefficient waste of time and resources. But it wasn't just America's highways. In the 1980s and 90s, in communities across the country, Black people were being targeted and imprisoned disproportionately for alleged drug use and trafficking. Many will recall the 100-to-1 crack versus powder cocaine sentencing disparity that sent many black people to jail, including my own relatives and friends. So while I was in the nitty-gritty details of litigating these complex cases focused on every fact, every legal claim, patterns and practice, my former ACLU colleague, Michelle Alexander, took a step back in an attempt to better understand what was happening at a societal level. I credit Michelle's groundbreaking book from 2010, The New Jim Crow, Mass Incarceration in the Age of Colorblindness, as one of the most important books in my life. For the first time, I fully understood how and why we got to where we were and what we as civil rights activists and lawyers were truly up against. Michelle placed the war on drugs and the mass incarceration of black folks in important historical context. She observed that because of the war on drugs, black men were imprisoned at a rate unprecedented in the history of the world. More black men are under some form of correctional control than were enslaved in 1850. As a consequence of imprisonment, black men have been relegated to legally sanctioned second-class citizenship, wearing a badge of inferiority that hinders employment, housing, education, or public assistance, and participation in the political process. This mass incarceration of black men, America's newest racial caste system, is the new Jim Crow. And like Jim Crow, mass incarceration operates as a tightly networked system of laws, policies, customs, and institutions that operate collectively to ensure the subordinate status of a group largely defined by race. At the end of the day, mass incarceration is a form of social control. The new Jim Crow explains how we got here, acknowledging that the war on drugs is the primary engine driving mass incarceration. Launched by President Reagan in 1982, it was a tactic to increase the political fortunes of conservatives rather than a response to the times. Drug use was actually on the decline. The crack epidemic that followed, however, made poor black communities a convenient scapegoat for drug warriors. The media and politicians, using race-neutral but coded and loaded phrases like tough on crime, conflated blackness with drug crime, creating the image of the criminal black man, all one word, a term coined by legal scholar Catherine Russell Brown. It didn't have to be this way. The targeting of black men and the war on drugs was not justified at all. As Michelle observed in her book, although the majority of illegal drug users and dealers are white, 3/4 of all people imprisoned for drug offenses have been black and Latino. This tough, racialized approach to crime was not the sole province of one political party. As a result of his attempts to increase his tough on crime bona fides, mass incarceration of people of color skyrocketed under Bill Clinton's administration. The Supreme Court's stripping of the Fourth Amendment of any meaningful protections really effectively shut the courthouse door to claims of racial bias in the criminal justice system. Even President Obama continued funding the ill-conceived drug war, and civil rights advocates also were to blame for failing to prioritize criminal justice reform, despite 1 in 3 young black men being under the control of the criminal legal system. So if I'm being honest, and I have a tendency to do that, even when maybe I should tell a white lie, as interested as I was in revisiting the war on drugs and mass incarceration per my assignment, as I told James, I I was just as interested in this notion of backlash, historical backlash that Michelle identified in her book. After I read the book, and that bit in particular, it all made so much sense to me. And as a native Wilmingtonian, the backlash that led to the massacre and coup of 1898 was of particular interest to me. Decades later, that massacre and coup continued to limit opportunities for Black people, my family included. Historically, when Black people have made economic or political progress, it has been met with backlash, and a good historian could tell us about that. From slavery to Reconstruction, from Jim Crow to the Civil Rights Movement, to the new Jim Crow, mass incarceration. And we're living in a moment of backlash as we speak, reflected in a huge rise in voter suppression efforts following Barack Obama's 2 terms of the election of 2020. That backlash is also reflected in anti-affirmative action sentiment and Supreme Court decisions, anti-DEI, anti-critical race sentiment across the country. Black Lives Matter is now less popular than it was before the murder of George Floyd. So Michelle said that nothing short of a revolution was necessary to overhaul America's inequitable criminal legal system. I've been deeply impressed with all the folks who have accepted that challenge, and many people have. There's definite progress, but it's far from linear. The summer of 2020 appears to have been more a moment than a movement. Black people continue to be over-policed and over-criminalized and to die disproportionately at the hands of the police. Poor people of color are hurt the worst. Collateral consequences of imprisonment still undermine employment, housing, education, and political participation. Our criminal justice work at the North Carolina Justice Center focuses on reentry, those returning from prison and re-entering society. Big shout out and congratulations to my colleagues in the Fair Chance Criminal Justice Project on their hard work in getting bipartisan legislation passed last week that will automatically expunge the criminal records of thousands of North Carolinians. Criminal justice reform is in everybody's best interest. So getting back to the Civil Rights Act of 1964. Upon its passage, Martin Luther King Jr. hailed it as the quote-unquote second emancipation. And while no one can argue that there has been remarkable progress in the past 60 years, more work remains to be done. The National Urban League's 2024 State of Black America report ranks Black America at 75.7 on the Equality Index. By comparison, in 1787, following the passage of the 3/5 Compromise, the score would have been 60 in today's terms. So there's clearly more work to be done. To fully achieve the promise of the Civil Rights Act of 1964, perhaps a third emancipation is necessary. What say you?